is some of the issues that when we're talking about the different regulations. One of the challenges that we have in terms of data protection is the user's consent. So we're talking about health, so this is sensitive data in some instances. So which is the legal basis for it? For instance, we find ourselves in a position where in some kind of services or some kind of products that are not very linked to a healthcare service, we may find this legal basis on legitimate interest, sometimes explicit consent, and sometimes we can find it also in another of the exemptions to the consent. But from an insurance perspective, we provide healthcare services to employers for their employees. So we also find for some other services, we will find our legal basis on the Article 9H of the 9.2H of the GDPR, which is about performing healthcare services. So one of the challenges for us is, okay, we need to really have an inventory not only of the services or products that we're launching to the public, but also defining all of the platforms, infrastructure, technological infrastructure, information systems that are behind them in order to make sure that when we gather the consent of the user, depending on which kind of services, we can have the evidence and the trackability to demonstrate that it is based on a legal basis. And this is challenging for us because right after, before GDPR comes into place, it was easier. You can rely on explicit consent you have over it, but in this particular case, we have challenges when it comes to sensitive data. And also, this is mine. No, this is yours.
Yeah. Your Mem Health Code, sure. Yeah, next couple.
Yeah, well, also, in our case, when we launch a mobile application, one of the things that we really need to make sure is to have all of the information detailed in the terms and conditions. So maybe, for instance, there are certain applications that only is the first step for the user to launch into a bigger platform. So let's say this second platform is controlled by some processor that we have hired. This processor is also has medical professionals that will answer the questions from the user through the app. So who is the data controller and who is the data processor, and at which point we need to inform and to make ourselves available to the user for the possible liabilities that will make the health professional who is in the other side of the platform. So this is really challenging for us. And we need to review our agreement between our medical scheme, our healthcare professionals where we have certain relationships, in order to make sure that when there's a relationship between controller to controller, we inform the user that, okay, you are going to use this platform, this application. This application is going to take you to a platform when you are going to ask questions about your health to a medical professional or a healthcare professional. This healthcare professional is working for a different company. They will have certain privacy considerations about your data, and they will be responsible for the services that they deploy. But I am also responsible as your insurer or some other issues. So we need to really define the line, the borders where my liability is considered, and where the liability of the other companies that intervene, whether they be processors or different controllers, also has to be determined.